How did I help a blended family with their estate plan? Hi, I'm Tanya Hendricks, Huntsville estate planning lawyer, and this is a case study on how I helped a Brady Bunch type family do their estate plan to ensure that all the kids are provided for, except for the one they didn't want to provide for. So, this is what happened. We had a couple who married after they had been previously married and had children from other relationships. And so, when they got married, there was a concern, mainly among the children. Well, what happens if dad passes away before she does? And then she changes the will, and all of her kids get what my dad accumulated through his lifetime. It's a valid concern, and honestly, that's a concern that uh, not everybody thinks about. You when couples are married, often it's the best of intentions, but you don't know what will happen when someone passes away. And it was actually my job to point out to these parents, this couple, that that would be a concern. That what happens if, because they come in saying we want everything to be divided between our kids, which want to be fair, and that's very commendable. But then I question, well, what happens if one of you passes away? You're still fairly young, and then the survivor gets remarried and can change the trust, can change the will. Um, what then? Do you trust this person 100% to not change anything? And so for this couple, it's not that they didn't trust one another, but it would just allowed their children to be at ease over that scenario, because that's how I posed it. What do you think your kids are going to think about this? What if there's a falling, you pass away and there's a falling out between your survivor and your children? You know, you just want to ensure that your children receive what they think they should receive or what you want them to receive. So, what I did for this family is I created two trusts. The mom had a trust and the dad had a trust. And within each of their trusts, they provided for their individual children, each other, obviously, too, but provided for their individual children. So, it allowed for their share of the estate to flow through and pass through to their children the way they want it to. And it put them at ease, put their children's minds at ease that these assets, because sometimes one of the parties coming into this new marriage, this Brady Bunch type marriage, has accumulated more wealth. And so you want to be sure that those kids um, are provided for, their children are provided for, and they're assured they're going to be provided for. So the trust that was created for the individual parties, once they pass away, it was revocable at first while they were alive, but once they passed away, it became irrevocable. So it cannot be changed by the spouse, by the surviving spouse. So that's what we did for them. And that put everybody at ease. We also, because we always do a will with a trust. The goal with any trust is to fund it, to put assets in it, but sometimes we forget. Sometimes we forget about this account, or we buy some property and do not put it in the name of the trust. So you do a will. And so they did what we did, what's called a pour over will. It catches anything that's not in the trust and pours it over into the trust. So if there's something out there, the will catches it and puts it into the trust. So we did two trusts, two wills, two powers of attorney, and two advance directives for healthcare. And the advance directive for healthcare is the end of life document. And because they have children from separate relationships, what we did was, for the wife, she obviously named the husband as her primary proxy, but the alternate proxies were her children from her previous relationship. His proxy was the wife first, and then his children from previous relationships. Because it is, I mean, it's deciding who's going to make that end of life decision for you, and it should generally fall to the children, because that's your family. Those are the ones who love you the most. Hopefully, not always. As with them, there was a child they didn't want to inherit. This child didn't agree with them getting married, and so they we made sure that person does not inherit from them. There was a provision we had to include. So that's basically the documents were created. Within the documents, though, you have to name for the will, you have to name a personal representative, but I always will include not just one, but the primary personal representative and an alternate or a successor, because you want to have that backup plan. You always need a backup plan. We never know what's going to happen. And so you always have a backup plan. So even though in the trust we have that their children get the money, what happens if one of their kids dies while they are still alive? Then their child share goes to their grandchildren or goes to their children's children. If there are no grandchildren, then it goes to their other siblings or their other children. So then that's the personal representative in the will. Let me get back to these designations. So we had the personal representative and an alternate. In the trust, we had, they're the initial trustees, their spouses are the successor trustees. And then after the spouses, we named their children. And so we had the primary, the alternate, and the successor, another successor trustee. The power of attorney is the same thing. Each other is the primary agent, but then we also had to have an alternate agent in case something happens while or something happens to the primary agent. Always have that backup plan. And speaking of backup plans, what happens if the parents are dead, the kids are dead, and the grandchildren are dead? That is not likely to happen in a lot of situations, but it does sometimes happen. And so you have to plan for that. And, I threw that at them as a curveball. Just about every conversation I have, I throw that question out there, and it is a curveball. People just don't think about it because you don't think the worst could actually happen. But that's why you come to an estate planning lawyer. That's why you talk to an estate planning lawyer, because we can develop the legal strategy that's best for your situation. And even though I just described how I helped a blended family do their estate plan, it doesn't mean that's what's right for your situation. And you can only figure that out and know that by talking to an estate planning lawyer in your area, in your state, who can talk to you, listen to your situation, listen to your goals and your wishes, and develop that estate plan that's best for you. And even though a lot of estate planning provisions that you'll see in like wills and trusts are very similar, they're all tailored to your specific needs. And so be sure that you talk to an estate planning lawyer to help you with your particular situation. I'm Tanya Hendricks, Huntsville Estate Planning Lawyer. If I can help you in Alabama, my number is 256-361-1221, or you can go to my website, HuntsvilleEstatePlanningLawyers.com. You can schedule directly from the website. So go to HuntsvilleEstatePlanningLawyers.com. Thank you very much, and I hope you have a great rest of your day. Bye.